When the Supreme Court decided New York State Rifle and Pistol Association versus Bruen in 2022, many gun owners believed the ruling would immediately dismantle large portions of modern gun control laws. That expectation was understandable. The court rejected decades of lower court precedent and announced a new way of evaluating gun regulations. To many people, that sounded like a reset, but that reset never happened overnight. Years later, gun laws that many assumed were dead are still being enforced. Permitting systems remain in place. Location-based restrictions have expanded. Certain bans are still on the books. And in many states, the day-to-day experience of gun ownership looks much the same as it did before Bruen. So, what went wrong? To answer that question, we need to separate expectations from legal reality. The Supreme Court did not invalidate all gun laws. It did not declare most existing regulations unconstitutional, and it did not order states to repeal anything immediately. What Bruen actually did was change the method courts are supposed to use when deciding Second Amendment cases. Before Bruen, nearly every federal court applied some form of interest balancing. Judges weighed the government's stated public safety goals against an individual's right to keep and bear arms. That framework allowed courts to uphold gun laws even when they burdened core Second Amendment conduct. The Supreme Court rejected that approach outright. Instead, the court adopted a text and history standard. If a law regulates conduct covered by the plain text of the Second Amendment, the burden shifts to the government to prove that the regulation is consistent with the nation's historical tradition of firearm regulation. That change was significant, but it was not self-executing. One of the most common misunderstandings after Bruen was the belief that laws deemed unconstitutional under this new framework would simply stop being enforced. That is not how the legal system operates. A statute remains enforceable until a court issues an injunction or a final judgment invalidating it. Bruen itself did not issue a nationwide injunction. It resolved a single dispute involving New York's discretionary carry licensing scheme. Every other gun law must still be challenged in court, case, by plaintiffs with standing under specific factual circumstances. That process is slow. Cases begin in district courts. They move to appellate courts. Sometimes they are sent back for further proceedings, and along the way, enforcement usually continues unless a court orders otherwise. Lower courts are now tasked with applying a historical test that is clear in concept but difficult in execution. Judges must decide which historical period matters most. They must determine what qualifies as a relevant analog, and they must decide how similar a modern regulation must be to historical examples. Those questions do not have easy answers. Some courts interpret Bruen narrowly and demand close historical matches. Others allow broader comparisons. Some treat certain modern laws as long-standing conditions on gun ownership rather than outright bans. The result is inconsistency. Different courts reach different conclusions about similar laws. Some strike regulations down, others uphold them, and many cases remain unresolved for long periods of time. During that time, enforcement continues. Another major reason gun laws remain in effect is procedural posture. Even when a district court rules against a gun law, that ruling does not automatically take effect nationwide or even statewide. Courts frequently issue stays. An appellate court may stay a decision while an appeal is pending. Sometimes the district court itself issues a stay. Other times, a higher court intervenes. A stayed ruling means the law remains enforceable until the appeals process is complete. This is not unusual. It happens in nearly every area of constitutional law. But from the perspective of gun owners, it creates the impression that Bruen is being ignored. It is also important to understand that many post-Bruen laws were drafted specifically to survive judicial review. Legislatures studied the Supreme Court's language carefully. They restructured statutes. They added historical findings. They shifted from outright bans to layered restrictions. These laws are now being tested in court, but that testing takes time. Many people ask why the Supreme Court has not stepped in more aggressively since issuing Bruen. The answer lies in how the court typically operates. The Supreme Court rarely rushes to enforce a new standard across the entire country. Instead, it allows lower courts to apply the framework, make mistakes, disagree with one another, and build a body of case law. The court then steps in when there is a clear split or when an issue has fully developed. This approach can be frustrating, but it is consistent with how constitutional doctrine evolves. The court is not simply waiting, it is watching how Bruen is being applied, where confusion persists, and which questions remain unresolved. In the meantime, gun owners live under laws that may eventually be struck down but remain enforceable today. So why are gun laws still being enforced after Bruen? Because Bruen changed the legal test, not the entire system overnight. Because courts, not headlines, determine enforcement. Because litigation is slow and procedural safeguards keep laws in place during review. And because the Supreme Court intervenes selectively, not continuously. The Second Amendment landscape is still shifting. The real impact of Bruen will not be measured in months, but in years. And the cases working their way through the courts right now will determine what the right to keep and bear arms looks like for the next generation. The fight did not end with Bruen. In many ways, it only just began.